thank the chair of the committee, the Honorable Ms. Justice Glenn Thompson, Justice of the Supreme Court, and the other judges and members of staff of the judiciary for the able way in which she and members of the committee have organized this conference. I shall be responsible for guiding this morning's deliberations. The theme, as you heard, is enhancing the role, relevance, and effectiveness of the ECOWAS Court of Justice through the strengthening of synergies between the court and national stakeholders. We have a role of learned and distinguished speakers who will dilate on the threads of this all-embracing theme, sharing with us their thoughts and experiences in and out of the court. Though the vast majority of speakers are from ECOWAS member states, there will be a few who will speak, as it were, from the outside. The underlying theme of the conference, as one will be able to tell, is how do we, the member states, give effect to the decisions of the ECOWAS court. The court has delivered numerous judgments on a multitude of claims brought by litigants in the member states. But what has been the effect of those decisions? Have member states complied with them? And if not, what should be done to get member states to comply with them? These are some of the questions we'll be asking ourselves, and the collective hope is that by the end of the conference, we would have arrived at some formula or consensus as to how effect could be given to the decisions of the court. This isn't supposed to be an unachievable goal. Being subject to a tribunal which is international in its composition is not a new thing in West Africa. Before independence from colonial rule, before independence, in English-speaking West Africa, there was just one to this court. It was composed of judges who sat at first instance in the former colony white until the late 1940s, when the likes of our own acting Chief Justice, Sir Ernest Betts, became a member of the court. But that's court's decisions were well of any kind by all and sundry, and its decisions are still cited by counsel in court cases right across West Africa, English-speaking West Africa. As independence came to then Nigeria in 1960. It was then transformed into the Sierra Leone and Gambia Court of Appeal until we too gained independence in 1960. When we severed the direct connection with the we are just one currency, the West African pounds, shillings, and pence. We have been making plans in recent years to return to that era of currency stability in which we will not need to do exchanges when we travel from one of these countries to another. Already, in French-speaking West Africa, the CFA is the common currency, whilst we in English-speaking West Africa are still using as several to gather ourselves together so as to act as one body. The East Africans have been going there, after going the separate ways after independence, have eventually, 60 years down the line, once more have a court who shall have jurisdiction over all of them. ECOWAS came into existence in 1975, but the court came into existence nearly 30 years ago. There became a growing awareness that for us to be able to manage our affairs in a more modern way, it was necessary to set up institutions with supernatural authority over all the member states of the community. There is strength in numbers, as the European Union has shown us, and as in recent years, the East African community has been showing us, and also the Southern Africa Development Community. There have been much debate about the overarching authority of the European Court of Human Rights, so much so that the United Kingdom opted out altogether from the Union. But there are still 26 other member states still tied to the European Union's institutions, including its court. Having an institution such as the court hearing cases and handing down judgments is not enough. There must be a mechanism in place which will ensure that these judgments are executed. This conference will be discussing and debating the manner in which this could be done within the framework of each country's judicial and legal system. We must bear in mind that the law in any country could be considered ineffective if sanctions imposed by it are not carried into effect. Each of our countries treasure our independence from external interference, but having voluntarily joined an organization which is supernatural in its aspect and in its work, we have implicitly agreed that it is beneficial to all of us West Africans to accede to an authority composed of individuals over whom we cannot exercise direct control. Just as in national jurisdictions, litigants might not like the decision of a particular court, but are prepared to comply with that court's decision, so too, there is growing belief that the same should apply to international institutions of which we are members. Notwithstanding this conclusion, we must take into consideration that one of the reasons why states are sometimes reluctant to submit to the decisions of an international body might be the absence of an appellate process. Litigants in individual nation states are comforted by the thought that if they lose in a court of first instance, they might win in a superior court, which has jurisdiction to overturn or reverse the decision of the lower court. Perhaps this conference, after its 4-day deliberations, might wish to give due consideration to creating or establishing an appellate structure, so that current court decisions are not absolutely final and unappealable. We have 3 official languages of the member state countries which will be used at this gathering. If we have learned to trust and to rely on the interpretations or translations of what one language speaker has said, I expect we will be able to trust and to give effect to decisions of judges who are not our countrymen. ECOWAS has been in existence, as I've said, for nearly 50 years. We ask that further consolidation and strengthening of the authority of this court. We are proud of the court. We Sierra Leoneans are particularly proud that one of our nationals, Julius, is a member of the court. He lives in a dearly departed brother, Justice Leone. Once more, Your Excellency, the President of the court, I wish all of us successful deliberations.
Your Excellency, the President, will allow us to take in through what we call the keynote address. This keynote address is going to be presented by Professor Ernest Abuchi on the theme of this conference. He is the Dean of the Law Faculty, University of Professional Studies in Accra, Ghana. He will take us quickly through this paper, and then we shall
Your Excellency, the President of the Republic of Syria, Julius Maada, Your Excellency, the President of the Court, Justice Edward Asante, all other distinguished protocols observed. In the interest of time, we're going to run rather quickly. Your Excellency, if I sound upbeat in tone as I commence my presentation to you today, then it is because I've observed with a great deal of satisfaction the sustaining progress of the ECOWAS Community Court of Justice towards entrenching the rule of law in West Africa. But even more importantly, the brazen desire of the court to embrace critiques in the evolutionary process of the institution. Having participated in the past deliberations of this conference, I am tempted to say without equivocation that the court and its president are on the path of moving forward, developing an institution that becomes the vanguard and epicenter of community justice within ECOWAS, and a model the world should replicate. In Plato's world famous book, The Republic, written more than 2,000 years ago, Thrasymachus teaches us an important lesson about justice. When confronted by Socrates with the question, what is justice? Thrasymachus boldly claimed that it is the interest of the strong That should strike many as a word today. But it's important for us to remember that when justice is administered without consideration of the interest of the weak, justice only serves the strong. Justice unconnected to the interest of stakeholders is not justice at all. That answer, however, also reveals something strange about the enterprise of justice. It is a desirable concept, but it's very elusive. And it is in the search of that ideal type that I believe ECOWAS has been involved in with conferences like this. For the purpose of doing its work, however, courts are not in the business of engaging with any constituents, actual or perceived. Indeed, the idea of courts having to network constituents may seem which is structured to be detached, neutral, and authoritative in its pronouncements, unperturbed by the effects of their rulings and consequences of their actions. But that is perhaps because the legitimacy of. But even more importantly, this dynamic may be the way it is, because municipal courts have routinely been effective in enforcing their judgments and securing compliance with their orders without having to worry about the surrounding context of sovereignty claims and enforcement deficits. Despite all these challenges, it is not surprising that municipal courts assume the detached posture they do, because they do not have to worry about the contextual difficulties of international courts. The topic of this keynote, therefore, examines the nascent at best, but novel at worst. In the main, the topic forces a reimagination of the relationship that should exist between supranational courts and sub-state actors, stakeholders. This is accordingly a normative reflection on how best to leverage the operational effectiveness of the ECCJ as a model supranational court which has since its establishment worked its way into acceptance and carved out an impressive niche of legitimacy deserving of protection and promotion. The topic of reflection is a quest for consequentialist efficiency in the court's work and how extrajudicial factors play central roles in the dispensation of justice. Your Excellencies. But more than that, the topic contains a hidden plea to democratize the institution of ECOWAS and more particularly the courts. The role of national and sub-state actors in deepening the effectiveness of the court can hardly be overemphasized, given their capacity to impact the operational effectiveness of the courts. From activating the action of the court to exerting pressure on governments to comply with the orders of the court in given cases, national actors and stakeholders remain pivotal in shaping the fortunes and prospects of the court. Networking them should therefore come as a natural consequence of the court's recognition of its own systemic place as a court, not only as a court, but also as a supranational court with evolving challenges, but also opportunities. Your Excellencies, they have had to make serious choices on the model of justice to be delivered in an international order characterized by legal inefficiency, the reality of political. National courts like the ECOWAS Court of Justice have to consider whether to maintain insularity or remain or engage with systemic actors . Yet, a consideration of the ECCJ's engaging local actors as an imperative of its own effectiveness raises many foundational but also fundamental questions. First, should the ECCJ of it laws applied and the procedural processes employed? On the other hand, the court's use of consequentialist models implies that it is concerned with the effect of its decisions on persons and entities affected. The relationships with these. Second, should the ECCJ adopt a posture of municipal courts and be reactive, stay detached from external interest, or should it be interested in victim impact and corporate engagement as a front-end proposition? The converse of this, Your Excellency, will be to have a court that is fundamentally back-end oriented and which takes a pro forma view of things. Third, are there justice benefits to creating a front-end actors? Are there risks of accusations of collusion, contamination, and partisan alignments from the court's engagement of local stakeholders, even before these entities or persons potentially become parties before the court in future? A thorough evaluation of these is critical to an assessment of various means of optimizing the operational processes of the ECCJ and local actors. By just proceeding from this angle will sorely miss the essence of the topic. For the topic demands therefore a reflection of the means of enhancing the relevance of the ECCJ indexed to the strengthening of the synergies between the court and national stakeholders. Viewed jurisprudentially, the issue of courts, their standing, relevance, and judicial equanimity in difficult times is one that deserves some comments in an address like this, given its sheer importance to an appreciation of the subject of the ECCJ's relationship with national actors. Framed as it is, the topic compels us to situate my comments in the context of the role of the court. So then, my statements are to be seen in the light of the regime purpose of the court and not an abstract evaluation of what a supranational court should do. Building on that, I have been invited to speak to you on the relevance and effectiveness of the court, and similar to the issue of purpose, I will briefly but concisely examine the relative relevance and effectiveness of the court before turning my attention to the core issues of the ECCJ's relationship with national stakeholders. Again, in the interest of time, unfortunately, I'll have to cut out some things, as I appreciate His Excellency's convenience. The role of the court, and that's the first key aspect of the conversation within the topic. Inevitably raises complicated normative questions. For the question, what role does the court play, contains an automatic derivative inquiry as to what role the court should be playing. Truly have come of age for nearly half a century of existence. For by its design, the court forms part of the larger ECOWAS project, and therefore it is to be grounded in that regional integration architecture. The design architecture and mandate of the ECCJ reflects the goals of the larger ECOWAS initiative, and the court purports to advance that goal. Indeed, it is arguable that the human rights and non-state jurisdiction of the courts reflects the evolution of ECOWAS itself, which have had to undergo necessary changes in the 1990s to accommodate the challenges posed by political instability, gross human rights violations, and autocratic rule within the West African sub-region. Fortunately, the ECCJ, like other regional courts, is invariably statutorily based, whose role and purposes tend to be textually spelled out. Thus viewed, the issue of the role of the ECCJ should be at least complicated of the four sub-issues reflected in the topic of reflection. With a mission defined by its constituent treaty, the mandate of the court is spelled out, and at the heart of that mandate is the interpretation of the text and the other subsidiary instruments adopted by the community. As a court situated within a regional integration project, the obvious mandate of providing a legitimate avenue for the explication and application of the text in real conflict situations is an important one, as it ensures non-development in the rule of law. That mandate reflects its jurisdiction as a judicial chamber and justifies its orders. The court accordingly plays the pivotal role of hearing cases and settling disputes among the various states of the community and between community citizens who appropriately invoke the jurisdiction of the court from time to time. When established, judicial institutions within regional integration initiatives facilitate the flexible evolution of the regional bodies by ensuring that conflicts do not result in the breakup of the integration bodies. As a court, the ECCJ provides a functional outlet for grievance adjudication, and this promotes regime stability. It is therefore surprising that throughout its existence, the court has been treated with attitudes reflecting lukewarm tendencies.
to downright hostility by regional actors in the sub-region, and some even questioning its relevance in the grand scheme of things. Yet critics and cynics need to be reminded that the court plays an important role of legitimizing the actions of other states, citizens, and ECOWAS itself by lifting contestations out of the realm of politics and open conflict into the arena of legal resolution. Thus, even when not used, its existence alone is a powerful statement of there being an accessible avenue to those who may have grievances to air. Your Excellency, beyond this, however, the presence of the courts is a means of perpetuating the rule of law within the community legal order. The elaborate jurisprudence of the courts serves to develop community law, but also ensures that the political decisions of ECOWAS as a group are tampered with and constrained by the rule of law. The default option presents the false choice of living with the implications of the legally problematic political decisions of the group and the dire ramifications for stability of ECOWAS. Yet, like all courts, the role of the ECCJ cannot get conflated with the roles and powers of the more political branches of the organization. And this is compounded by the fact that in the event of territorial or jurisdictional conflicts between ECOWAS and other institutions within ECOWAS, it is still the court that has to determine the boundary issues of which organ has overstepped its bounds. The court has speak to a case of deeper inter-institutional statement of power and authority, which in the long term can only be settled in favor of the court, but needs to be carefully managed to avoid weakening the institution. In terms of its role in non-explication, the ECCJ's jurisdiction applying the Africa Charter of Human and People's Rights implies that the court stands in a unique position to localize broader regional rules contained in the ACHPR and make them contextually relevant. The specific jurisdiction in view of the court will allow us to build jurisprudence of that treaty in a manner obviously superior to the much chastised system that formerly prevailed. By investing the court with the jurisdiction to hear and determine cases on the abuses of human rights arising out of and under the ACHPR, the constituent treaty of the ECCJ has succeeded in reinforcing the external accountability of member states in their respect for human rights. Your Excellency, Mr. President, given the effect of shaming on states when held to have acted wrongly against their own citizens by international tribunals, the President of the courts and its determination to stamp out impunity through its decisions will help shape the behaviors of governments and ultimately foster a right-based approach of doing things within the sub-region. The ECCJ is relevant. But an examination of the role of the ECCJ can best be understood and looked at another way, namely that the court as an enabler of community policy legitimation and realization. Being fundamentally political in character, contestation in the policy articulation, formulation, and implementation within ECOWAS is high. The ECCJ can act as a stable counterweight to this by being used to test the legal viability and justice. In advancing or reducing disagreement among states on key policies of the community, but also to legitimize policies adopted. Although experience in the EU shows that the decisions of the European Court of Justice are often constrained by politics within the EU, including threats of legislative override, I argue that this prospect behaviors of states in West Africa, at least as experience shows so far. The threat of legislative override is not dominant in West Africa, and the contrary of what we have experienced is a silent tendency not to enforce decisions of the courts. Relevance of the ECCJ. My discussion on the issue of relevance will be begun by a self-query, asking, relevant for or to who? For the issue of relevance is inextricably interlinked with the constituents served by the subjects involved. For the ECOWAS court to be deemed relevant, it must accordingly meet certain minimum criteria, including its role discussed above, its relative importance to the ECOWAS project, how it advances or promotes key values shaping its formation, and finally, its continuing evolution and adaptability to new circumstances and its impact in general. As a treaty-based regime, the entire ECOWAS arrangement hinges on the pre-commitment of members to the collective legal mandate and vision of the integration initiative. That's understood, only the court has the institutional wherewithal to help guide the process on the path to actualizing the vision. That pre-commitment requires that there is an inclusive engagement with relevant institutions, member states, and stakeholders of ECOWAS through the formal processes such as adjudication, interpretive clarification, and development of norms as the institution develops and evolves over time. But in addition, it is contemplated that the court employs wider engagement tools which transcends its formal deployment of jurisdiction. Significantly, there is an inevitable prospect of conflict characterizing the evolution of ECOWAS institutions, and ECOWAS is no different in this regard. Evolutions entail changes and novel policies, and these are often challenged either by endogenous or external forces, and very often the successes of institutions become measured by the extent to which they are able to both leverage and overcome these conflicts or tensions. Courts provide the requisite steadiness and stability required for the productive evolution expected. In the absence of apex courts like ECOWAS, conflicts will be left unchecked due to disintegration in general. But even if factually relevant, as asserted, the question may still be asked: why should the ECCJ continue to Iranian fashion? One needs to acknowledge the reality that courts are often looked down upon with disdain by those with incentives to misbehave or amass power in any experiment involving institutions. Experience with other ECOWAS institutions, as earlier mentioned, speaks to this reality. The acceptance of the court by the broader stakeholders and substantive actors within ECOWAS is functionally dependent on its rule, tyranny, and dysfunctional governance within the sub-region. Relevance in this context challenges the courts to remain in the forefront itself, its parent body, to see the point. Achieving the latter, especially, can prove both tricky and difficult, as courts are not in the business of influencing policy, or even clearly showing an intention to nudge it. But when institutions are given red mandates, they are nuanced. So here we are. Our very gathering here is a testament to a court which recognizes stakeholder importance and the dangers of insularity and disengagement. To stay relevant and functional, therefore, itself from the shackles of conventional courts, shun aloofness, and pursue a path of engagement. As I have been asked to speak on the court's engagement with stakeholders, it is important at this stage that we recognize the importance of the imperatives of engagement and the virtues of the courts existing for its stakeholders, members, and actors, and not for ECOWAS as a body alone. Finally, in the sub-theme, effectiveness. An effective court is one that meets what I call the judicial criteria, namely, 1, dispensing justice; 2, enjoying a regime of enforced judgments and orders; 3, advancing a body of convincing jurisprudence; and 4, enjoying a broad public acceptance of its work. These indices of effectiveness are vital to the court's ability to scale the bar set by its mandate. The court's duty to dispense justice is at the core of its mandate. The obligation to interpret the text of the treaty and promotes its application between member states is an important mediating tool and has helped the court to assist member states, ECOWAS as an organization, and the community citizens to come to terms with the ECOWAS project. For the future direction of the community, the court must build on its achievements thus far, but must also perhaps adopt bolder and more imaginative instrumental and jurisprudential leadership in helping shape the future of the community founded on original ideas. Using the model of European integration and the activist role of the European Court of Justice, the ECCJ can assert its strong role in the evolution of the integration process through its decisions on social partnerships and legal influences. If the ECCJ succeed and become effective moving forward into the future, it must be seen and preferred as the preeminent dispute resolution chamber of the region in matters falling under its jurisdiction. In other words, community citizens must think of ECOWAS and the ECOWAS Court of Justice when they have disputes once the court has jurisdiction. It mustn't be seen in a subsidiary fashion. But even more crucially, the ECCJ must have its decisions enforced in order to be deemed as an effective body within the panoply of community institutions. A court whose decisions are deemed brutal fulmen or simply ignored by those affected by it is bound to attract scorn, ridicule, and ultimately fail. In this context, I will sadly again recall the regrettable failure by some institutions of ECOWAS itself and some member countries to refuse to enforce decisions of courts, and these may have undermined ultimately not only the court's own effectiveness, but the impressions of legitimacy the court is supposed to ensure. Similarly, convincing and functionally viable jurisprudence, and this is very important. The philosophy of law built by a court is central to its standing, effectiveness, and social acceptance. One cannot ignore the quality of scholarship advanced by its judgment and the legal as well as syllogistic dimensions of its reasoning. For as it has been said in comparative constitution, the ways of the scholar. And it goes without saying that the ECCJ needs to construct a body of principles, doctrinal concepts, and structured scholarship through its judgment designed to reinforce the solidity of its judgment and the social attraction of its decisions in general. Building a body of convincing jurisprudence is utterly important to the acceptance of the court by its constituents and stakeholders, but also in the best interest of the institution. Crucially, however, it is noteworthy that a court such as the ECCJ cannot build the expected qualitative jurisprudence if it does not elevate its decisions above the worries of uncertainty. Learning from other institutions, the European Court of Justice being notable in this regard, the court can erect standards such as the margin of appreciation in human rights jurisprudence, direct and indirect application of rule between community rules and local laws, in statutory and administrative interpretation, among others. And while the court has been very good in developing its own novel tools to interpret the text of the community, it is imperative that sometimes comparative constitutional and international law can assist the courts in this vein. Finally, in respect of effectiveness, the most important measure of the court's effectiveness is its acceptance by the public or publics that it serves. Acceptance here needs to be given the nuanced conception required and should be understood to import a recognition of its legitimacy and the absence of on its operation. For in principle, courts need no acceptance, given that their effectiveness is built on power and force, and not popular acclamation. cases and submit complaints all depend on acceptance and a recognition that an institution, that as an institution, it does have the capacity and motivation to dispense justice to those who come seeking its help. Public acceptance of the court cannot only reinforce its sense of legitimacy, but also deepens its knowledge base of local and cultural nuances of justice. I dare say that in the context of public engagement, the ECCJ is perhaps without power and continues to evolve models for others to copy. Our media is tested this time. But more needs to be done by the court in this vein. Among others, the court needs to identify tools at the micro level, tools at the national level. The court needs to go beyond the national stricture of boundaries and borders and engage actors. The ECCJ, at this stage, I'll briefly address you, I'll skip a chunk of what I've written, but just address you on the fact of the ECCJ's, the relevance of the court's engagement with national actors such as the courts. It goes without saying that the court has a mandate to engage national actors in order to be effective. Its own statute or treaty compels the court to enforce its judgment through local courts and ensuring that appropriate jurisdictional processes are initiated in order to enforce the judgments or decisions of the court. Experience has shown that the ECCJ has struggled, at least in some cases, to have its judgments enforced by local courts. And without mincing words, one cannot ignore the silent jealousies that exist between supranational courts and local courts. Some of these silent jealousies manifest in the character of local courts seeing supranational courts as entities that are overstepping their bounds by asserting some degree of appellate. In the case of ECOWAS, the Court of Justice is not so structured, but given that it's an international court, sometimes the impression is created that one is superior over and above the other. ECOWAS, again, in the interest of time, I finally move to the last section of the presentation by speaking to you on the question of building a model of engagement between the ECOWAS courts and national actors. Directing attention to the skeptics of judicial engagement vis-à-vis the medium to end users of the court services who need to be engaged, harnessed, and employed in the court's work. In terms of mechanics, the mechanics of engagement present a much more formidable obstacle that needs to be negotiated and overcome. More specifically, the question of what the specific mechanics of engagement should be can be vexed and complicated. At the macro level, consideration can be made of the dialectics of whether the court should be more direct or subterranean in its approach or dealings with constituents, or questions of whether the court should adopt purely legal or extra-legal variables in its engagements may also come up. Others may yet raise questions as to whether this should entail ongoing or sustainable contacts, or this should only be ephemeral or sporadic from time to time. Admittedly, I do not profess to have the answers, but I'll share. Systemic barriers as they address entities or stakeholders that are not within their jurisdictional domain. In this context, however, the court may deepen its own innovative engagement strategies, including rotational, but also innovative engagement model, which has the potential of democratizing the justice goods presented by the courts. The advantages of in-country sitting is that the court is brought closer to the persons who are President, Excellencies, my people obviously should be available for distribution. I finally go to my conclusion. As I finally go to my conclusion, the need for the ECCJ to engage and network its end users and the surrounding context of its operations may appear rather too obvious to merit any serious actions. Should the Court of Justice focus on the known task of administering justice, simplicity, and remain aloof to the decisional impact, outrages, and apathy of the public itself within the member areas of ECOWAS? The ECCJ experience shows that the court's development is importantly connected to its engagement of key constituents, as well as the people themselves. As has been seen in the presentation, this cannot be left to the processes of accretion, but must be thoughtfully nurtured towards an instrumental end in the process. Yet it is equally a truism that the engagement of its justice constituents can in real terms prove problematic. The court's current model of courting local ACTA cooperation is a useful start, and its model of promoting doorstep hearings within the countries and the member states promises to deepen the attachment of member countries and the citizens to the work of ECOWAS. It is my hope and belief that the court will move beyond its current achievements and further deepen the relationship it enjoys with both the institutions of ECOWAS and, more importantly, other key stakeholders within the member countries. Thank you.
I would like to thank His Excellency for his generosity of time. He was celebrated yesterday by family and friends, and I would like to invite you to celebrate him today by a round of applause. More, please. Happy birthday, and it is my pleasure to invite His Excellency Julius Maada of the
My Lord, the sixth President of the ECOWAS Court of Justice, the Honorable Justice Nicholas Colin Bramack, the Acting Chief Justice, Your Excellency Dr. Omar Ali Toure, President of the ECOWAS Commission, my lords and my ladies, justices of the Superior Court of Judicature of Sierra Leone, member states, ministers of government of the Republic of Sierra Leone, your worships, members of the diplomatic and consular beautiful country, Sierra Leone. I'm indeed pleased that ECOWAS Court of Justice chose Sierra Leone as the ECOWAS community of West African states in 1975. And she remains a firm concerted and best efforts. Such cooperation and integration would impart the key to the sub-regions and the promotion of peace and prosperity for our people. The ECOWAS Court of Justice plays a pivotal role in advancing across the region. The court's establishment in 2001 was a welcome step towards fostering integration and cooperation. In commending the leadership of the ECOWAS Court of Justice, I must add that progressively justice delivery options to the citizenry of ECOWAS community. This may be connected human rights of the community's citizens. The added layer of checks that the court provides will not only raise awareness ranging from political instability and social unrest to economic disparities and transnational crime. Resilience within our community. It is during times of adversity that the strength of our regional solidarity and commitment to shared values become most is timely and significant. It reminds us of the fundamental principles that underpin It also resonates very well with our domestic justice sector reform efforts. It is our sincere hope that will be on offer during this conference and similar conferences in the future. In Sierra Leone, promoting good governance and ensuring access to justice for all citizens, we recognize the critical in safeguarding the principles and providing recourse to those whose rights have been violated. We note in particular that the current composition of the court has one of our own Honorable Justice Mohammed Sengu Kuruman from our Supreme Court. There are cases on your docket that bear our name, and we continue to engage our legal professionals and explore legal options available to us. In access to justice and strengthening the rule of law in West Africa. I urge all member states to support the courts in its mandate fully. The course towards a brighter future for the people of West Africa. My lords and my ladies, of the Republic of Sierra Leone, therefore declare this International Conference of ECOWAS Court of Justice duly open. Thank you, and once again I extend my warmest welcome to all of you and wish benefit our people, region, and uphold the noble ideals upon which ECOWAS
Sapco Fishing Company, initially they deal with fish, just fish, like buy and selling of fish. But now we don't branch out, forget a sardine factory. So these are the 4 sardine factories in Sierra Leone, yes.
We there for show one thing. Something President Bill very care about, what they call value addition to we raw materials them. So Sapco, we done the fishing for many years. Don't decide, say, for the very first time, then they open the first factory, sardine factory na West Africa. Imagine, first sardine factory na West Africa, na Salon. Today, na President Bio, the commissioner.
Na idea wey come to me, for let we fish the value, for let we help export, it help with economic, for let we help bring foreign exchange back.